Lord, we just come before you right now, God, and we pray for your wisdom to be present with us today as we listen to Julian. Feed us some information that's going to be helpful for us here in the restoration of our rights and our fundamental freedoms, God, that were inherently given by you. Lord, we just pray that your presence be with us, your Holy Spirit guide us, and God, that each and every one of us be protected for the upcoming issues that we're about to face. In your holy and precious name we pray, Lord Yeshua. Amen.
Amen. Thank you so much, Mark. Beautiful
Thank
thing. Rick Martin is actually on the line. I know that there's some things that he wants to discuss, and we have quite a few other people on here that I'm sure have some things to say, which is a beautiful thing. So I welcome you all on. And now Teresa just sent me the prayer. So hang on. I guess she doesn't want to read it, so I'm going to have to read it. Dear Heavenly Father, we come before you with heavy hearts, lifting up our dear sister Holly in prayer. We humbly ask for your divine intervention and healing touch in her life. You are the great healer, O Lord, and we know that nothing is impossible for you. We ask that you lay your hands upon Holly, granting her strength, comfort, and relief from any pain or suffering she may be experiencing. We pray that you guide the hands and minds of the medical professionals entrusted with her care, giving them wisdom and discernment as they work to diagnose and treat her condition. Lord, we also pray for Holly's family and loved ones, that you may grant them peace and the strength to support her during this challenging time. May they find solace in your presence and be a source of encouragement for Holly. As we gather in your name, Lord, we remember your promise in Matthew 18:20, for there 2 or 3 are gathered together in my name, there am I in the midst of them. We claim this promise, knowing that you are with us in this moment, hearing our prayers. We place our faith and trust in you, knowing that your plans are always for the good. We ask for Holly's complete healing, both physical and spiritual. You will be done, O Lord. Your will be done, O Lord, and may your grace and love surround her in abundance. In Jesus' name we pray, amen. So, with that said, Julian, I'm going to mute, and you have the floor.
Well, thank you very much for that prayer, Mark and Michelle, Teresa. And thank you, Michelle, for giving me the opportunity to speak to your members tonight. I'm just going to give you all a brief presentation about what I teach and what it can do for you. So equity is one of 3 realms of jurisdiction laid out in our Constitution. There's equity, there's common law, and there's admiralty, maritime, statutory, or commercial law. It comes from about 500 years ago. It originated in the courts of England. And the definition of equity is that it is the law of justice and fair dealing which seeks a more adequate remedy than that which is available in common law. And it originates from the Bible, just as all our laws do. So equity understands that everything is commercial. First of all, in 1933, our true constitutional money, gold and silver, was taken from us. Gold, quote unquote, hoarding of gold was made illegal. In reality, people were just trying to withdraw their gold to feed their families, but that's the line that was used, and so they took away our gold and gave us paper instead. Because the Constitution made gold and silver the only true tender for settlement of debts, FDR and everybody else would have been traitors by their own laws, except that they gave us a remedy, and they just didn't tell anybody what it was. It took people about 90 years to figure it out. But in equity, we use what's called the acceptance, and this compels equitable discharge of any matter before us. So after 1933, they brought in their federal rules of civil procedure, and the case of Erie Railroad versus Tompkins, well, it started as a guy just walking by the railroad tracks, and an open train door broke his arm, and he sued them, and it exploded into this huge case where they're questioning whether there's even a federal common law. And by the end of it, one of the Supreme Court justices commenting on the case stated that now everything is commercial, and they merged equity and maritime statutory law and common law all under the same court system. In my opinion, this was done to hide equity because it gave the defendant too much remedy. But now everything is commercial. So even going next door and asking your neighbor for a cup of sugar is commercial. The great thing about equity is that it makes you the accounting defendant. It basically makes you a banker. Because everything's commercial, everything has a price. Even if you steal a car, and you're in court defending yourself, and there's a criminal charge, there is a way to settle that by paying. And before 1933, if you had brought equity, you would have had to just pay a bunch of gold. But since they took away the only money to pay what we can't pay, now we just pay with our signature. But I'll get into that later. There's a big difference between in-law and at-law. When you see attorney at-law plastered all over billboards around town, just know that that's a fiction. And Black's Law Dictionary defines at, one of its synonyms is near. When a lawyer says they're operating under the color of law, it's a fiction. Color only means the appearance of being real, i.e. fake. So when we stay in law, judges have to recognize our equity. A lot of people that ask me, hey, I did my status correction, now I'm ready for your equity class. But no, equity requires no particular status. We're not afraid of the all caps name. We don't try to hide from it. There's no reason to sign anything with UCC 1-308 or any of the ways that people try to get around that. We understand that people need to deal in Babylon still need to handle matters in commerce, and so we make that option available to you. We teach you how to do that safely and privately as the living private individual. So the only preparation you need is research and practice, and we'll talk about that more. But one of the big things that most teachers out there are not going to tell you is that the Constitution itself makes contracts the supreme law of the land. Now, if you read Article 1, Section 10, Clause 1 of the Constitution, if you read just these underlined portions here, it says, "No state shall pass any law impairing the obligation of contracts." So when people say, oh, the judge is acting fraudulently and deny me my motion and all this stuff, well, what I always ask the person is, did you agree to a contract? If it's a traffic case, do you have a driver's license? If it's a criminal case, did you sign the pre-sentencing agreement? Even adjudication, where the judge asks, do you have anything to say before I sentence you to 10 years in federal prison? If you start making claims and arguing and testifying, that gives them the right to put you in prison. Ronald Reagan appointed a Supreme Court justice named Robert Bork in the 1980s. And he was all set to get the nomination and be a Supreme Court justice until he gave an interview on live TV. And he said, everyone that is in prison is there voluntarily. And of course, Congress railroaded him after that and took the nomination from him. But he was speaking to this idea of contracts, that under the fiat system, under the color of law, at law system, all these laws are voluntary, and they're just experts at getting you to contract with them. So we contract away our Bill of Rights every single day. And in equity, I teach you how to stop doing that and how to undo any of the contracts that you entered into by mistake. One of the biggest and most important maxims in equity is that the position of the defendant is preferred. Even after judgment, the position of the defendant is preferred. And that's when we get our remedy, is after judgment, before sentencing. So that's extremely important. And if it doesn't look like you're getting preferential treatment in the court system, if you've tried many things and nothing's working, then I suggest you try something new. In order to receive equity, one must do equity. Attorneys can't do it for you. We have to bring it ourselves. The big way that we stay in honor, and there's a whole system of honor and dishonor in the court system that most people aren't taught about, but what we do is we ask questions and we get facts onto the record this way without testifying. That allows us to stay in honor. And one of our big questions is, Judge, how may I settle this matter today? What we're not told is that it's considered a commercial dishonor to argue, to testify, to state facts, to make claims, to file motions, to file basically anything at all, to hire an attorney. All these things are dishonorable. This whole notion of honor and dishonor actually comes from old maritime law, where, back then there was no instantaneous communication like we have now, obviously, and people would send a negotiable instrument halfway around the world, and they would need provision to be made 6 months from that time at a certain port at a certain time, a certain amount of food, fuel, ropes, and whatever else the crew needed. And if somebody decided to argue with that negotiable instrument or to not honor it for whatever reason, people could die. An entire crew could die. People's lives are on the line. So as long as that negotiable instrument was made in the faith and credit of a bank or a local trust, then it needed to be honored. And so these things are still present today. You do not argue with a charge. If their books need to be balanced, then they have to be balanced. So we teach you how to come as the accounting defendant and help the court to balance their books in every matter. Doesn't matter what the matter is. It could be a debt. It could be a criminal charge. It could be a mortgage. Equity gives a remedy for all of it. So just remember, we can't pay for anything. If you'd brought equity before 1933, as I said, you would have had to just pay a certain amount of money to make these things go away. But since they took away the only constitutional money, now we can just pay with our signature. It's the remedy they gave us and didn't tell us about. So we can discharge any charge according to the remedy established in 1933. Any debt, any criminal charge, any warrant, loan, court order, citation, anything can be discharged lawfully and honorably. Anything that you're given with your name on it, you have a liability and a power. You must reply to it, but your reply has the power to cause discharge. It puts the liability on the part of the person that offered it to you to give you your equitable discharge. And if you look up discharge in Black's Law Dictionary, under equity practice, it says, in the process of accounting before a master in chancery, which is basically anybody who can take an oath. I mean, even the garbage man at the courthouse can take an oath. The discharge is a statement of expenses. So is not, if the judge woke up on the right side of the bed that morning or if the sky turns purple. Discharge is a statement of expenses and counterclaims brought in and filed by way of set-off by the accounting defendant, which follows the charge in order. Well, of course it follows the charge. I mean, you don't pay before the charge unless you go out to eat and you eat and then they give you the bill. Set off is an accounting term, but it basically means balancing both sides of the ledger. So in equity, we do actually access the private side of the ledger, but we are allowing the judge to do that for us to set off the whatever charges are being brought against us. It's all about accounting because there's no actual money, so we just help them balance their books. Miranda versus Arizona is an equity case, and it told us that our rights are in peril whenever we feel compelled to talk, whenever we have blue lights in our rearview mirror, or somebody knocking at our door, or a call from a debt collector, or a summons to court. So instead of creating controversy by arguing and testifying and filing things, we just ask questions. And I teach people how, when somebody asks you a question, I teach you how to answer that question with another question. Claims always have to be proven, so we don't make any. So we talked about the conditions of honor and dishonor. Most people get themselves into tremendous amounts of dishonor, filing things with the IRS, arguing in court, challenging jurisdiction. I mean, all these things are dishonorable, commercially speaking. So I teach people how to stay in honor in every aspect of their lives. One of the biggest maxims in equity is, in order to do equity, one must come with clean hands. And that means not mixing equity with any other processes, just asking questions and using the law of notice and using the questions that compel the performance that we want to see happen. So how do we stay in honor and discharge any charges against us without arguing, testifying, or filing anything? Well, after 1933, all the laws governing commercial matters were updated to say, instead of just payment being a remedy, it's payment or acceptance now. So when your name's on something, you have a liability to honor it. I'll teach you how to accept presentments, demands, charges, loans, offers of every kind, and give proper notice and accept it in a very particular way to set off the accounting on any matter. We've seen thousands of criminal charges disappear, hundreds of families getting to stay in their homes for the rest of their lives, debt-free, when they were facing foreclosure before. Just amazing, amazing results. There's people that have been doing this for over 20 years that have been in the Patriot movement for over 20 years, just trying everything. And they have all told me to a T that equity is the greatest remedy they have ever found. There's just 4 books that we use. I teach directly out of Black's Law Dictionary and Burton's Legal Thesaurus. These are 2 books that every judge knows very well. I use their own law books to prove everything that I'm saying about equity. So you don't have to take my word for it. If you take my class, I'll show you exactly where in their law books these things are spelled out. We also use Levine's Manual on Commercial Law. Lincoln Levine was a New York CPA that figured out the laws changed in 1933. And in the 1940s, he wrote a manual that talks about the whole acceptance process and everything. So very useful piece of literature there. And of course, the Holy Scriptures, the Bible, is what all these laws are based on. Matthew 5 actually has a few really choice verses in equity. Talks about how you need to agree with your adversary quickly, lest he deliver you to the judge, and the judge deliver you to the officer, and the officer throw you into prison, where you won't come out until you've paid the uttermost cent. And that's what we do with our acceptance. We agree with our adversary. We don't argue, and we just help them balance their books. You'll find that you'll be getting a lot better treatment in court when you come in honor with equity. And here's some terms you can look up in Black's Law Dictionary and Burton's if you have a copy. And all these terms will have equity in the definition somewhere, just for you to get a better idea of what we're doing here. Acceptance, accord and satisfaction, account stated, account rendered, color, defendant, discharge, form, law, lawful, offer, and presentment. So one of the best things about equity is that it's actually profoundly simple when you really learn it. There's about 4 or 5 really major tools that we use, and then maybe half a dozen smaller tools. And it's just a matter of applying these things in the many, many different situations that people find themselves in when they're ensnared by Babylon. But common law is extremely strict. Common law basically says, if you steal, you get your hands cut off. I mean, there's hundreds of thousands of remedies in common law, and they're all extremely precise. They have to be done at this point in the case. They can't be done at this point. You have to know case law and precedent and memorize a lot of stuff. And equity only has one remedy, but it trumps all of them. You don't have to memorize endless amounts of procedure, regulations, case law, any of that. Just leave all that for the attorneys. The maxims of equity prove that equity is above commercial law and above common law. And another big issue with common law is that there's many maxims of law which are not arguable, which state that local customs supersede the common law. This is the issue with common law remedies, is that nobody really tells you that customs supersede that. But equity is above all of it, and I can prove that to you from their own law books. So some really important maxims of equity. Equity seeks to prevent the wrong itself. And down here we have equity regards that is done which ought to be done. These are kind of related, but from 2 different angles. Equity will obey a contract to the letter of a contract, but it also gives you a remedy if you entered into the contract by mistake, and nobody can tell you that you didn't enter into it by mistake. It's a very easy remedy to use. So if you consider a contract immoral and you didn't know that when you signed it, that's a mistake, and equity gives you a remedy for that. We can undo anything of that nature with equitable rescission. Another one is he who seeks equity must do equity. And that's just about not mixing processes, coming in honor, staying in honor, leaving in honor. Equity will not suffer a wrong without a remedy. So equity gives you a remedy for any situation that you might find yourself in. As I said, it works for criminal charges, civil cases, any kind of debts, loans, mortgages, every situation in which you're a defendant. It's not for being a plaintiff and putting claims against your brothers and sisters. It's for being a defendant and being left the heck alone by the government. He who comes in equity must come with clean hands. That's again just about staying in honor. Equity aids the vigilant and not those who slumber on their rights. Well, that's not to say that if you leave something on your desk for a year and don't respond to it, that you're just, up a creek. I mean, equity works on constructive notice, meaning that it can actually time travel, go back in time, correct errors that were made 20 years ago, redeem property that was lost 30 years ago. I mean, it's incredible the reach that it has. So the slumber on their rights part, it just goes a lot smoother when you respond to things, when you reply to things quickly. But equity has constructive notice, so any amount of time that's passed is not an issue. There's no statute of limitations in equity. Equity regards that as done which ought to be done, and equity will not aid a volunteer. And that last one is pretty important. It goes back to the whole idea of contracts that I was talking about before. If you volunteer for something, if you receive the benefit, then they own you. So if you're receiving some kind of benefit from the state and you have a matter tied to that benefit, you're going to need to give that up in order to bring equity to it. But it's very rare that somebody would not want to do that. There are many contracts that we enter into by mistake all throughout our lives. And all our lives, we've acted as if we're surety for that all caps name. You can say that you're the beneficiary all you want, but if you're walking around with a birth certificate and a driver's license and a car registration and selective services signature on your selective services card, then you are acting as surety for that all caps name. And you've done so all your life before you ever learn anything about the law. So equity tells you how to get out of those contracts if you entered into them by mistake, and it gives you a remedy for anything that might have roped you into. So here's some success stories and testimonials, and then we're going to get to some more of these from a couple of students of mine, but let me read you some of this stuff first. There was a woman I studied with who was dealing with repeated threats from the IRS for tens of thousands of dollars worth of mispayments. And she brought equity, and it took about 3 or 4 months. They went back and forth a couple of times. She kept getting those 2645 Cs where they would say, we need 90 more days to figure out what the heck is going on, and we'll get back to you. And then finally, they sent her a letter actually apologizing to her. She said, "Thank you. I just got a letter yesterday saying the case was resolved and they apologized for the error. They actually apologized to me. I've been fighting this for years, and all it took was a few acceptances. This class has changed my life." There's a friend of mine who got pulled over speeding. He said, I gave him a script, how to deal with the officer on the side of the road in an honorable way, just asking questions. And he said, "That script worked. I only had to ask one question, and the officer handed me back my papers and let me go. I wanted to use the whole script, but he clearly didn't want to deal with it." And I've heard that hundreds of times by now. It's a pretty amazing script. And when you apply equity you can apply equity to any situation in your life where somebody's trying to compel you to do something, and it's just had an incredible success. Here's another one. Oh yeah, this one's actually mine. I discharged $20,000 of credit card debt for my wife. Yeah, it took 8 months of acceptances and inquiries, but she's now completely debt free. And my mentor has discharged millions of dollars in debt. Just remember that we are paying. Technically, because of their laws that they set up in 1933, we pay with our signature. We're not getting out of anything. So this is one reason why this works so good. All these banks and insurance companies, hospital bills, all this stuff can be paid for with a signature if you do your acceptance and your notice in a very particular way, which I teach. I teach it down to the letter, exactly how to write the notice, and everything else in this class. I will show you highly specific examples. But all these things are able to be brought to the Fed window by the institution that you're discharging with, and they can get paid. They want to fight you a little bit sometimes because they care more about control than they care about your money. But it only takes a few months in most cases. So, and oftentimes it takes 2 or 3 weeks. So, it really just depends. But yeah, that's one reason why this works so well. There's another guy that my mentor told me about. He's a yacht owner. He's arrested and ordered to attend a deposition by the judge. They're trying to steal his yacht from him, basically. The attorneys asked him over 200 questions, and each time he would just say, "I would love to answer that question, but the high court has ordered me to shut my mouth." And of course, this is referring to Miranda versus Arizona. The attorneys were screaming at him, getting red in the face. They finally went to go tell the judge what he was doing, and the judge just dismissed the case. So he appeared. I mean, in order to attend a deposition, only tells us to appear. It doesn't say we have to testify against ourselves. So this comes down to, just really reading the contract and making sure that you are, that you're staying in honor and not acting against your own best interest. Here's a mortgager that I got to see this discharge. He lost his job due to an injury, and he was unable to make his mortgage payments. He tried everything he could find, but nothing was stopping the foreclosure. It was only buying time. He was in foreclosure for 2 years when he found equity. And the man who taught me taught him. And after some rescissions and acceptances, 2 weeks later, he received a letter stating, "Thank you for your payoff funds." He's going to get to live in his home for the rest of his life, fully paid off. Now, I'll go ahead and say that's not the norm with mortgages. Okay, it doesn't usually happen in 2 weeks, and it depends a lot what state you're in. But equity provides a remedy 100% of the time, no matter where you are and no matter how far in the case you are. The only factor is how well you can internalize it and apply it and speak before the judge when it comes time. There is never a case that we have lost when the person applied equity properly in the way that we teach it. That alone is the greatest thing about equity, in my opinion. I mean, common law remedies, they work great sometimes, but they never work 100% of the time for 100% of the people. Equity is the only remedy that can say that. Here's a very recent case that my mentor took on. A young man was charged with felony possession of a firearm in Chicago. He's facing years in prison because you aren't allowed to have a gun in Chicago, even though it's like one of the only cities that you really, really ought to have a gun. So he was caught with one, and after he learned equity, he showed up in court and he brought equity. And the judge yelled at him in front of everybody and told him to sit down and be quiet and he'd deal with him later. And then the judge just chewed up everybody in the courtroom until it was just this young man left. And then he dropped the act, and the judge actually left the bench, came down into the court and put his arm around the young man. And he said, "I know what you're doing. You're trying to bring equity to my court. Just take this gun class and this will all go away." So that's the power in this. Equity makes you equal with the judge. Federal judges know this and they respect it. Imagine never having to worry about going to the mailbox, getting a knock at the door, seeing lights in your rearview mirror, receiving a call from a debt collector or a tax agency, or being challenged on anything ever again. That's what equity is about. It's a very advanced course that will teach you everything you need to know about how to bring equity and stay in honor and make you untouchable as a defendant. So how much is that worth? Do the math on that. I mean, IRS issues alone for the rest of your life, never having to worry about that. Think about it. So I've basically given you the outline of how it's done. If you really wanted to just bury yourself in Black's Law Dictionary and Burton's and Levine's, you could figure it out yourself. But if you'd like in-depth training and guidance on how to create these notices properly and how to properly do acceptance and rescission and all the other tools that we use, and if you'd like the option for one-on-one private coaching, then just private message me. Just remember that templates don't work for this, that all these notices, all our paperwork has to be customized for the individual and their particular situation. And although a lot of our matters get discharged before they ever have to go to court, a big part of my class is teaching you how to speak before the judge, no matter what they throw at you. And that's really important because anybody can go download a notice online, but knowing how to defend it in federal court is a whole nother story. And that's what I teach. It's half of what I teach. So a big subject takes time. These classes are held once per week on Tuesday nights. Class is going to run for 12 weeks. All the classes are going to be recorded, and we'll give you the ability to watch those recordings for the rest of your life. I'm going to keep the classes to 20 students at the most. And I also make myself available to you for the rest of your life in order to answer any question that might arise for you. If it's a more complex matter, then we can discuss that. But for anything that you need help with procedurally, or just basic questions and stuff, reminders, then I make myself available to all of my students until I take my last breath. So you can PM me on Telegram for details on how to register. My username is @vitiate0. So that's VITIATE 0. And I've got a testimony recorded here from a student of mine. Let me get that on the screen here.
Hey, Julian, I really wanted to thank you and take this time to thank you for this equity class. It has totally opened my eyes to what I've been thinking and wondering for years concerning employment taxes and how to deal with property taxes and how to legally and ethically deal with these things. And your class in equity, the pace of it, going step by step, demonstrating, proving it out, if you will, has been amazing. Not too slow, not too fast. It's been great. And then the fact that you're recording it, I can go back and watch it again on video, so I can, get the details and the nitty gritty. So thank you so much, Julian. I highly recommend your class, and thank you so much. I really, really appreciate it. Thank God for you in this class. My eyes have been open. It's been an answer to prayer. Peace be with you.
All right, and I think some of my students are actually on the call tonight. So if any of you would like to share your testimony, now would be the time. Please just raise your hand, and we'll get
actually, James is an admin too. So James, are you with us?
Yeah. Hey, Michelle.
Hi, how are you?
Good.
So what do you have? You took Julian's class, first class. So what's your feedback for everybody?
Sure. Yeah, we're class is still going on. It's just about finished. But Michelle, my background was a bar attorney for a number of years. Stopped doing that around 12 years ago. And a few years ago, saw the David Street videos, all this, Patriot stuff. And, some of the stuff resonated, some didn't make sense, but always had, always knew there was some answer out there. Looking at the common law as well. And I'll tell you that the equity class, just the whole mind, it's not really there is a process, but it's also a mindset and a mentality and just kind of a way of approaching the problem that's completely different. It's something it's counterintuitive. In other words, things that you're taught, other people that they do some remedies, sometimes they work, sometimes they don't. But when you looking at Julian's class, the materials and how it's presented, there is a way, there's an answer, there's an easier way than what everybody else has been doing, and it's and again, it's been hiding in plain sight. It's as Julian said, everything was paid for. 1933 changed everything, but we never, we're always going to war. Everything is controversy. Lawyers, bar attorneys, they make money when there's controversy. And so they're always trying to, you're filing motions, you're having arguments, you're petitioning the court, as opposed to just understanding the process and what's going on. So we're always angry. They're pitting one side against the other. We're always pissed off. I'm angry all the time. You see with the injustice in the world, but there's a remedy for that. Once you kind of, Julian's class definitely opened my eyes to this. And once you kind of see the big picture and the process and how, it is the matrix. There's this whole spider web out there, but then there's a pathway to navigate through there in honor and simply deal with the issue and resolve it. You're resolving the controversy, and at the same time, you're paying off the national debt by settling the accounts. And like I said, I'm still I'm still doing working on my presentments and such, so I don't have any hard success that I can tell you. But I'll tell you, it's certainly an ascension of the mind in terms of when you.
We lost you, James.
I don't know. Sorry, go ahead.
No, you went silent for a minute.
Oh, sorry. But how it's presented, looking up the terms once it's laid out in front of you, it makes so much sense, and it gives you a peace. It's an ascension of the mind because you really understand that you're asking questions, you're eliminating controversy, and you're settling the account. That's every single case, whether it's IRS, a bill. It's basically the same mentality, same approach to everything. Whether it works the first time or the second, that eventually it is going to work because you've got the history, you've got the rules of equity, behind you. So I don't know. That's all I can say at this point.
Thank you, James.
Well, hang on a minute. I want to elaborate on that a little bit. James, you've been listening to Boris. You've been listening to Derek. You've listened to Rick. You've listened to Kirk. Out of all the people that you've listened to, what are you finding that's actually working?
Everyone you've mentioned, everybody is, and those are all great patriots with, we're all searching for the answers, right? And we, believe me, we all want to find the way. We want to do justice, and we're all struggling, which is, I guess, this is why we're put here to struggle. I've gone from. It's kind of funny. I'm trying to think because I originally saw the David Stray stuff. That I saw Kirk. I was following that, and then I heard some of Rick's stuff as well, and Rick had great success. But then I came upon Derek in June. I was helping somebody in Florida that was incarcerated down there just for practicing law without a license. Completely ridiculous. I won't go into all the facts, but she actually was released from jail a couple weeks ago, which is great. But I came upon Derek, and I love Derek's stuff. His stuff is so organic, and Derek hammers every door. If they don't open it, he'll knock it down. But I've noticed in Derek's approach too, he's kind of leaning more toward equity as well. He's going toward a more peaceful approach. He's understanding that there's you don't have to blast the door down. Sometimes you can just walk around it, and then that's just progression. Then I came upon Julian a month and a half ago or so, and it was like a logical progression to me because Derek was kind of leading into equity a little bit. I heard Julian. I think I signed up immediately when I heard his original thing. Something just resonated with me, whether just his sincerity, and it just seemed to be the logical path. And I do additional research outside of the. I read and copy. I got crap all over the place. I'm still so far behind reading and researching, but it was the equity approach when you see it and it's laid out, I mean, it's in your gut. We all know that things should be simple. We weren't placed on here to be struggling. I mean, the equity approach is just, it's almost like, I don't know, I guess I equate it to, instead of like karate where you're fighting, it's like a judo move where you're taking the other side's momentum and you're turning it to your advantage. You just don't know you have the power within you. You don't know that you have the tools to settle the accounts. And, you know, we all have it. And, you know, Julian really kind of took the essence of everything and made it simple. And I look at it this way. Look, I paid for law school. I paid for law school myself, student loans forever, 50, 60,000, whatever the hell it was, plus a lot of time and effort. And in fact, I told him when we were talking originally, I'm like, this is like a graduate level 3-hour course that I'm paying for. And for me personally, I mean, this is the beginning of my process at Equity. I'm not going to learn everything. It given me the tools. I know I have more to learn, but once you kind of know you're on the right path, like you're going east, and that's where the destination is east instead of walking west, that's very reassuring that you know that at least you're on the right track. And then it just continues to build in my knowledge and, you know, kind of using the tools and then expounding on them to go to higher and more difficult challenges, like eventually, you know, property taxes and then mortgages as well. So I don't know if I answered the question, but it's my journey's been, you know, I've been in the law for 30-something years. So, and it's all ending here at Equity, which for me, it's a logical progression. It's just, I like Occam's razor. I like simple. I like no controversy. I'm not afraid of a fight, but there's a simpler way to solve all the problems we're facing. And I'm completely sold on the equity. That is the path. So.
Well, thank you, James, and I just want everybody to know I did not pay James.
No, you didn't. I say it sincerely and freely, and it's from the heart.
James always has an opinion and something to say, and I always like to listen to what he has to say. I think James is a great guy, and I think you are too, Julian. But I see Rick has his hand raised, and I see Lucky has her hand raised. So I'm going to unmute Rick. Rick, I hope you have a question. Go ahead, Rick.
Mute. Am I unmuted?
You are.
Awesome. And I've got to commend Julian on exactly what he's saying, and love the fact that Jim chimed in. There's one thing that I would like to throw out there. We're dealing with an unlawful system, and we're trying to bring it into acting lawfully. Now, in my early successes, and I'm in total agreement, going equity. And the way I used to approach court cases in the early days was, Judge, I need you to ask the prosecutor to certify my right to subrogate. And that usually made the prosecutor turn white immediately. Because, yes, we are dealing with equity courts. There's no getting around that. What I'm going to suggest is, we need to start bringing that courage back to the table. Do these public servants actually know? There's a lot of judges that are on the bench that are not even aware of what they're doing. We have a lot of young prosecutors out there that are not aware of equity. And I think that's probably one of my biggest dilemmas that I've had to transgress over the past 3 years since the scamdemic. And everyone knows I've gotten myself locked in jail cells. But I think what I need to explain is lawful versus lawlessness. And these courts, I'm about ready to win my appeal court case because lawlessness was demonstrated by the circuit courts, and they're going to continue to do that. I don't want to mislead anybody that they're not going to be damaged. However, if you are damaged, yes, exactly what we're talking about, we can seek that remedy in equity. And if you were to take a regular sheet of paper, and I would like for you to start from the bottom left-hand corner and draw it all the way to the top right-hand corner. And I want you to put common law on the left-hand side of that line, and I want you to put equity on the other side of that line. Where you have to remain to stay in honor is walking that fine line. When a judge asks you, how do you plead? That is automatically trying to drag you into dishonor. And I just need to make that public. I am not here to argue. What I'm here is to basically challenge the jurisdiction of this court. And I would like to settle an account. I would like the prosecutor to certify my right to subrogate this case. And then on top of that, because I have been unlawfully arrested, I need to be indemnified for my damages. And I believe that's where we need to start working. If I'm mistaken, somebody please correct me. If you don't know what subrogation is, I will tell you quite clearly. Subrogation is I'm not the party, but I'm also a party of interest. And I'm going to turn it over, as they call the straw man case. Okay, I'm going to turn it over to that. And where I'm going is, all right, now, because I've been the injured party, I need to be indemnified. And I'm probably blathering on a little bit much here, but I definitely want people to start paying attention to subrogation, because that is all about equity. And remember what I said, when you bring out a piece of paper, draw a line from the bottom left-hand corner all the way up to the right-hand corner of that page, diagonal. Put one side, the right side is equity law. And then the left side, common law. Think about, I heard the razor bit. That was great. You've got to walk down that razor. But you also asking questions. That's what the whole thing about what I've dealt with, all these other cases that I had thrown out, was the judge's interrogatories. When you start asking a judge is going to start getting nervous, because most judges, not all, but most judges will realize the trap that you're setting them. And you're taking them out of admiralty maritime law and bringing them back into the common law court by using those questions correctly. I've never had a judge in all my life ever say, when I say, Judge, may I ask a few questions for clarification? Before I even make a plea, may I ask some questions for clarification? I have never had a judge in my entire 33 years of dealing with this ever say no. And I use that to my advantage to start asking pointed questions to the judge, to basically grab him into one jurisdiction to another. The common law is Article 3, and that's where you want to bring them back into. And those that are aware of what you're doing will vacate the bench or try to shut you down. With that, I'm going to yield.
Yeah, I would like Julian. Can you respond to whatever to everything that Rick just said, as far as equity is concerned?
Sure. Yeah, thank you. So in equity, we have a duty to inquire, and we have a duty to come in equity, stay in equity, and leave in equity. But it's not our duty to teach them the law. And I'll guarantee you, most federal judges in this country absolutely know about equity. There are federal judges all over this country that we've put in dishonor, public commercial dishonor, in their capacity as a private individual. And this is one of the things that we use to help compel performance when they're trying to stonewall us. So one of the things that we say, instead of walking the line between common law and equity, we stand on the rock. We stand on the firm foundation of equity. And I truly believe that about 500 years ago, the Lord God used equity to preserve his law in the courts of men, just as Babylon really started its death spiral. And that this is our truest remedy, to stand wholly in equity. You can stand on, some people call it standing on your square, and they got a million different ways they try to knock you off of that square. They'll try to recontract with you 6 ways to Sunday, but that's why one of the biggest things I teach is how to speak before the judge. We would not challenge jurisdiction in equity. We actually want the judge to have jurisdiction because he's the only one who can give us our remedy. So there is a lot about this that is very different. As James said, it's kind of an entire perspective shift. People have only really been applying this for about 10 years now. As I said, it took about 90 years for people to figure out, how to apply this. But in equity, we want the liability. We want full liability, and we take full responsibility. We just don't admit guilt to anything that they're charging us with, but we absolutely take full responsibility, and we accept whatever we're given. If they're charging us with 16 felonies, we accept every single one of them. We don't argue with it. We don't challenge jurisdiction. We don't argue the facts, law, jurisdiction, or venue. That's one of our biggest sayings. And by doing that, we stay in honor, and we bring honor to that courtroom, and we receive our remedy. So yeah, it's a big perspective shift.
Can I ask? In equity, do you get monetary remedy or no?
It's not for going after people for things. It's how to be left alone. It's the art of being left the heck alone, some people say. And so we don't use it as a plaintiff. For being a plaintiff, you would need to come out of equity, and I know that you and Rick have a lot of good material on that if somebody ever needs to come out of equity and go after somebody that really, truly wronged them. But this is about how to be untouchable as a defendant, how to discharge any charge that somebody is trying to bring against you, any debt, any warrant that's out with your name on it. It puts you in a fortress that is unassailable as long as you fully internalize it and don't mix it with anything else.
So is it like that you're standing above the law under God?
In a way, I mean, it makes you equal with the law, actually. It doesn't put you above the law. It makes you equal with the law, and it makes you equal with the judge. The judge is the law speaking, so you become his equal. It's based on God's laws, yes. And the maxims of equity put it above commercial law, put it above local customs, and because it's above local customs, I mean, you could say that it's above the common law. But it is just the purest essence of moral right doing that the courts were originally supposed to be all about, and have gotten so far away from that. It's such a broken system now. But this is how we compel them to act morally and ethically.
So one other question, and then I'm going to call on Mark because he had his hand raised first. Someone brought to my attention just recently that in every county, there's a judge that is in charge of equity and chancery. And I was told to contact that judge privately and have a private meeting with them to stay in equity, because that judge that is in charge of the equity and chancery has a higher say than all these other fake, phony judges. Is that true?
Well, I know that the state of Delaware and Tennessee, and I think one other state still has chancery courts. But after Erie Railroad versus Tompkins in 1938, all the courts are merged under one court system, and they got rid of the chancery courts. And that's why the last book that was written about equity is from 1908 by Henry Gibson, Gibson Suits and Chancery. So there are 2 or 3 states that still have chancery courts, and technically, small claims court and family court are technically chancery courts. The issue with them is that they involve lots of arguing, which immediately takes you into dishonor. So you can't really bring equity in those courts as well. Yeah, it's bringable in any court in the country. I mean, you could take it all the way to Supreme Court if you want to. And just because Article 3 federal courts and Supreme Courts are the only ones that can see the actual living man and all the other courts only see fiction, every judge in this country took an oath to the Constitution, and equity is enshrined in Article 3, Section 2, Clause 1 of the Constitution. And we've just seen it work thousands of times, no matter what court you're in. So it doesn't need to be in a specifically chancery court. You don't need to go seeking a chancellor. It'll work in any court in the land, and it works in any country in the world that has a constitution. So basically everywhere except for North Korea and China. And
wow, that's something.
Yeah, we have a lot of students that I learned with in Canada that are bringing equity in Canada right now and seeing great results, even though what we thought was the friendly neighbor to the north turned into a terrible tyranny.
What, James?
Hey, Michelle.
Hey, you unmuted and said something?
Yeah, I wanted to just, if I could interject, I completely understand where Rick's coming from. Rick, you're very passionate. Believe me, for me, making this flip, equity is a leap of faith. I mean, it is biblical. I mean, you're basically, and this reminds me of something that Derek said in his recent class that he said with his court case, where he went in there and said, "Judge, the facts are not in dispute," and that's Derek really bringing equity, whether he calls it that or not, because there is no dispute on the facts. It's just a question of how this is going to be resolved. In other words, as Julian says, you're not filing motions, you're not challenging jurisdiction. You want to settle the account, and equity is what allows you to settle the account. Now, not the way that they may have thought it was going to go, how they've done it with other cases, but it is a leap. It is a leap of faith, and it's the more you get into it and understand the basis, and that's the whole thing. It's not like some template or process. You understand the roots, and then that's how you're able to stand on the rock, because you know from whence it came. You have the origin, and you've walked the walk. So anyway, I'll yield.
Well, thank you for that. Mark, you had your hand raised. I unmuted you. Do you want to ask a question?
Yes, please. I got a million questions, of course, but I'll try and limit it to 2 basic things I have in my mind. First, I just wanted to say hello to Rick and brother. Glad to have you on here. And good to be in a group with you again. And whenever you're going to take the world by storm and be that leader, I'll be the first one behind you, brother. As far as this equity goes, I know that you can't mix. You got to come with clean hands. Is that to say then, if I've got a court case that's been going on almost 2 years, and they just they're not answering me. They haven't answered me for over a year, but they put out a warrant. Nobody will really pick me up on it, but it's there nevertheless. I'm wondering if there's a way. Does equity provide the means to ask the forgiveness and then come again with clean hands? Is there a way to do that so I can give them notice that I would like to get forgiveness of the court, say, and then and then settle the account from there. Is that something that's available, Julian?
Absolutely. If there have been mistakes that have been made, if there's been contracts that have been signed by mistake, any dishonors like challenging jurisdiction or filing certain things, then absolutely equity gives you a remedy for every possible situation that you could find yourself in as a defendant. No matter how long it's been, even if there's a warrant out, equity will give a remedy.
Oh, that's excellent to hear that.
Okay. Go ahead, Ryan. Neo?
I'm here. Apologize. First off, Julian, thank you for the presentation. Much appreciated. I've studied equity early on, and of course, with helping people with different court matters, it just goes back and forth, and there are so many different avenues and angles of remedy that are being taught, and it's quite vast. And one of the things that I always seek out is also being a man of the scriptures my entire life is applying what would be most efficient and at the same time simple, as they say, keep it simple, stupid as possibly as you can. Like where attorneys bring controversy, there's often a lot of confusion and disarray. But the thing that I wanted to ask you, and I kind of wanted to chew off of what Rick was saying in regards to lawlessness, whether it be mortgages, credit cards, any type of obligation, either whether it's criminal charges or, any a civil issue of some kind. We are in a lawless, broken world, and you have gypsies, tramps, and thieves out there that come to loot, pillage, rape, and plunder. Just in the past few years, I helped get people out of hospitals back during the scamdemic, that people were being taken medically captive. They were trying to override and completely ignore people's advanced directives. I mean, there was just the past few years, I think people can agree, we've seen more lawlessness than we'd ever hoped to see or imagine. Like, say, the fact that like a lot of these mortgage contracts, credit card contracts, all these different things, I mean, they're built upon so many constructs of fraud. And there's a lot of forgery going on too. I mean, if people knew the amount of forgery that was going on just with birth certificates and going on with mortgages, they'd, want to barf up their freedom fries. So, and I've had this feeling before. I'm a very critical thinker, and sometimes we'll go into places where maybe some people are, maybe afraid to tread. But it seems like, even though while equity is a remedy, it seems like, and, I'm asking you to correct me if I'm wrong, but equity, even though that it's providing a remedy, it seems like at the same time that it's keeping the corrupt system in place and allowed to ever revolve and keep in motion. And as far as for myself is concerned, like, I know that where equity asks questions, and sometimes, and actually I shouldn't say sometimes, exposition is always an effective remedy. Like it actually says in the scriptures that we're supposed to, we have a duty to expose the unfruitful works of darkness. And then we have to rely and remember that God's vengeance is his, and he shall repay. Like the evil in this world, it's not our duty. We don't have the power and capacity to destroy it. We don't necessarily have the power and capacity to take this system, put it in the toilet and flush it, and then fill the bucket with a new system. I mean, ultimately that's God's power over on. But I just want to know what your opinion is in regards to the system that is in place now, as far as equity, just, providing a remedy. How is that in contrast to the fact that all the lawlessness that we see is equity, while it's providing a remedy, is it allowing the system, of course they're just trying to balance their books, but is it allowing this system to still maintain and stay in place?
Well, short answer, no. But as you said, it's not up to us to right all the wrongs of the world. Now, what I say is that you need to get your own house in order before you can be of assistance to anybody else. And so if somebody's coming after you, if somebody's trying to throw you in prison, then there is no better remedy to be left alone in that matter than the one provided in equity. It is absolutely not perpetuate the system. They can print as much money as they want regardless. I mean, as I said during the presentation, they don't really care about your money. That's why they push back when we bring equity. They want the control. So, I mean, helping them balance their books, I mean, sure, that's how we get ourselves left alone, but it doesn't perpetuate anything. And the more people that learn equity, the fewer people they'll be throwing into prison. So there's actually this is a nascent movement that is gaining steam, and you have the opportunity to get on the ground floor of something that can truly protect you and your family for generations. So that is how I would answer that.
Ryan, Neo, do you yield?
Yes, I yield. Thank you. Thank you, Julian.
Julian, does this also help with CPS cases, with them taking the children?
So it can absolutely help in the role of the defendant, not for going after CPS. I mean, you would need to come out of equity and look for plaintiff remedies on that. But it can help you stay in honor, and it can help you settle matters that would make you look unfavorable to CPS. When it comes to family court kind of stuff, there is inherently a demand for argument, a demand for controversy that has to be met by both parents, or in this case of CPS, you have to make claims, you have to defend yourself. So that is technically inequitable. The idea is to not get ourselves into these contracts in the first place, and so that's a big thing about what I teach is how to avoid contracts that you don't want to be a party to. So there's a lot of fraud out there, but if you agree to the contract, then you enjoined yourself to the fraud. There's a big maxim of law that says where there is consent, there can be no fraud. If you take your child to wellness checkups, which are just basically marketing events for vaccines, all that doctor has to do is make one phone call, and they can get your children taken away. So don't take them to the wellness checkups. And there's a number of other things. I mean, my heart goes out to people that are only learning it after stepping into these snares, and I do everything I can to help them. But when it comes to family matters, the remedy is less direct. What I offer, it can still help you bring yourself back into honor and appear more favorably to these people and get your children back that way. But and it can teach you how to compel performance from people by asking questions that prick the conscience and imply tort liability down the line. Absolutely, that's helped many people protect their children. So yes, it does help. But as far as a direct offensive against the beast system in those matters, no.
Okay, thank you. So we have a couple of questions. Blessed, you've had your hand raised for quite some time. Go ahead.
Hi, thank you very much. Julian, thanks. This has been really great, especially when you're trying to navigate roads and which one, and sometimes you're going in circles. And so I appreciate everything that you've said. And one thing that you mentioned, if you accept 16 felonies or a criminal charge, how is that not then on your record? Does equity, once you accept it, it's different than saying, okay, you're not that you're saying you're a felon. So I wondered if you could just explain that, how it gets wiped away and then it would not be on your record is what I'm guessing. And then with a mortgage, if you do discharge it, is there any, with equity, is there any room for recoupment. We have a really messy mortgage over several years with several refis, so there's a lot going wrong. That's gone wrong in there from our mistakes. So yeah, that's it. I appreciate it. Thank you.
It's my pleasure. And so just for everybody else, the first question was asking about how acceptance works when they're throwing these criminal charges at you, and does that not go on your record and make you a felon and all that? The answer is that this highlights the difference between consent and assent. When you consent to something, you agree to take on the guilt of it, and you just agree to whatever the court wants. When you assent to something, you're not arguing, you're agreeing with your adversary quickly, but you are not taking on the guilt. And so our acceptance works as the accounting defendant. We're just accepting their negotiable instrument, their charges, their court order. All these things are commercial. All these things are a negotiation. All these things have a monetary value. So when we accept as a banker would accept, it's a lot different from consenting as just somebody who doesn't know, who's just getting charged with something would consent. So we accept and return for settlement and closure the accounting on the matter, and our records are clear. And as far as the other question about the mortgages, there is a redemption process in equity. It's a lot lengthier of a process, but people have had their land redeemed to them. Now you do have to ask yourself, if there's another family living on that land now, and I do my equitable redemption, they're going to get kicked off that land. Am I really okay with that? And can I provide them? Can I make them whole? But if your mortgage,
there's no one kicked off the land, because we're in the house, and payments are up to date. If you,
I see. Okay. So the mortgage issue, it depends if you're in a judicial or non-judicial foreclosure state, how easy that's going to go for you. I tell people, do not take on a mortgage until you have learned equity to a deep enough level to where you can teach others, because that for mortgages, the banks push back harder than anything else. And equity does what it says it'll do 100% of the time. But in a non-judicial foreclosure state, they're going to take you all the way through that foreclosure process, and you're only going to get one shot in front of the judge at the very end, after the house many times has already been sold. And you can get your remedy there if you know exactly what to say in front of the judge. But otherwise, you just got to make sure that amount of stress is okay with you. And I tell people, if they're in a non-judicial foreclosure state, and they can make those payments, then just keep doing that. However, if you are desperate and you're not worried about the stress, and you believe that you can internalize this well enough to make that one shot in front of the judge count, then absolutely, equity can 100% discharge a mortgage in any situation. It's just a matter of how well you can internalize it.
And then judicial would be different then.
Initially, you get many opportunities in front of the judge in a judicial-only state, because a lot of states give the option for judicial or non-judicial, and of course the bank's going to choose non-judicial most of the time. So, but if you're in a judicial-only state, then you're going to have many opportunities in front of the judge to get your remedy. It's a lot easier.
Okay, thank you very much.
Okay, G. G, you had your hand raised. You can talk now.
Oh, could you hear me? Okay. My question was, I heard from someone that there are two schools of equity law. I heard there was pre-1933 and post-1933. Could you tell me what schools of equity law do you teach, Julian?
Absolutely. Thank you for the question, because that raises a good point. So pre-1933, as I talked about, all the laws were changed after 1933 when they took away the gold and silver, and all the laws were changed to say payment or acceptance, and in some cases, payment or performance, and that performance is just acceptance. But what I teach is post-1933 equity. So this is the fully updated true equity, as some call it, that just teaches you how to use that acceptance when there's no gold and silver. In the modern world, there's some people out there teaching pre-1933 equity, like Rourke and Phelps is, the example that comes to most people's minds. And Rourke is an excellent historian, and he's extremely knowledgeable, but there is no real remedy in pre-1933 equity. I mean, it requires highly specific. It's almost as specific as common law. I mean, the judge has to be on vacation in private quarters, and then you have to have this very particular manner of speaking with him, and you really only get one chance at it. And I've never heard of it working for anyone personally. I know that there's other things that Rourke uses which have helped people, but I don't believe there's any remedy outside of post-1933 equity. And I personally would not teach something that doesn't work 100% of the time for 100% of the people.
Okay. And is it also part of your process regarding about getting a named decree, so you can put your name in the private and also using equity law with it?
So none of that is necessary to bring equity. Equity requires no particular status, and we are not afraid of the all caps name. We know how to use it to operate in commerce. And I mean, we present ourselves as the living sentient being, the upper middle, upper lower, first middle last name, as it were. But I think that's a term that gets thrown around a lot in the patriot community, and it's really not necessary to do all these things with the name. I mean, you just don't argue and don't create controversy, and understand how to ask these questions that compel the performance that you want to see happen, and then do your acceptance and your rescissions if necessary according to their own laws. And we don't need to do anything with the name.
Thank you. I yield.
Ruby, you had your hand raised earlier. I unmuted you. Did you have a question?
Yeah, I am just learning equity, and I was able to get a case dismissed. It wasn't anything crazy. So my question is, thinking back on everything and the content here tonight, when a case gets dismissed, of course they're not going to, but they're supposed to, give you your bond. Would there be an equitable way to require that, or would that be a completely separate type of process? I'm not going to bother with it. I'm just wondering.
So that's actually related to one of the, or a couple of the questions that we asked to compel performance about the bonds. I'm not going to get into the specifics of that publicly, but we are looking to them to discharge the bonds associated with our cases. And just the fact that we can ask about this in a certain way pricks the conscience and compels them to give us the remedy that we're seeking. I mean, basically, with a lot of our questions, we're saying that we can do a lot more damage to you with our equity than you can do to us with anything that you have. And that's true, because if the judges talk about the bonds on the public record, if they say too much about them, they could lose their judgeship. So there's some questions that we base around that are very good at making the judges sweat.
Thank you. I yield.
Maggie? Maggie, you had your hand raised earlier.
Maggie's here with me. She's got something to say.
Hey, I'm Julian's wife and help to assist in teaching the class. And I just wanted to address the gentleman who brought up the spiritual component and scripture and, fighting the powers that be and all that. And so we know if we are people who follow scripture, that there's an unseen agenda of a demonic presence that we know that we're fighting against as well. And the beautiful thing I think about equity is its spiritual component. It addresses both forgiveness and repentance. And these are two of the most powerful tools that Yeshua gave us. and although they seem like a weakness, they're really very powerful, and they're used very powerfully in equity. And so I believe that learning equity and teaching equity is also following how Jesus told us to spread the gospel. And that was by word of mouth and teaching others, the Great Commission, that sort of thing. And so that's also what these classes are doing. And I believe that spiritual component is we are on the cutting edge of teaching a way of thinking, a way of life that it's life changing for people. As we said, people who have some issue going on or who are just learning it to learn how to navigate life. And we're gathering people in a community way as well, helping each other, because there's as many ways to apply equity as there are people applying it. And so it's evolving constantly, and we're learning, and we're on the cutting edge. And I believe that it is a spiritual movement that's going to change the way that courts and judges and lawyers and attorneys have to start dealing with us. In Scripture, it says we perish for lack of knowledge. And so this is extremely important knowledge for us to learn, to apply,
Come out of her, my people.
And to come out of her, my people. And I yield.
Thank you, Heather.
Yeah, thank you for that. Jennifer, you have a question?
Yep. Just wanted to know, I didn't know we were doing a call on equity, but my question was, what is the law that the judges have to do their oaths with their full name, or does that even not matter? Because I have a dirty title, and it was recorded without our knowledge. We don't even know how it got in this house. But anyway, the recorder of deeds certified this and recorded it on the record, and it is clearly, when I first looked at it, I said, oh my God, they set us up for a land grab. I'm not on the mortgage. My significant other is. And we just realized this about a week ago, and had a consultation with someone, paralegal, today. And she said there's absolutely a land grab. I cannot believe that the recorder of deeds certified it. And we were looking at her name. She goes by first, middle, period, last name. And I know that the oaths, the public officials have to have their oaths in their full given name. So that was my question.
So there is I can't remember exactly where in United States Code it is, but I've seen it before. It's in there. But as it pertains to equity, it's Article 3, Section 2, Clause 1 of the Constitution that they swore to uphold, and so that does form some of the questions that we ask regarding the oath. So there's definitely a couple of tools that we would use in your case. Recording a security interest in the property through a certain public channel is one way that we would do things. I can't really go into too much detail on that here. And the other is Ron Gibson's land patent is another tool that we would use in that case. And those are just to buy time while the person learns equity. You can discharge anything that somebody's coming after the property with. So I don't know if they've turned it into an active court situation yet, or they're just hanging on to that title, keeping it in their back pocket. But if you were to learn equity, then you would have everything that you would need to discharge that matter if that ever did become an active issue for you.
Yeah, we actually did do a certifying funds, but they defaced it, tore it off the memorandum, and sent it back to us. Okay, that was it. I can't even think right now.
See, ma'am.
Okay, Veronica. Veronica, you have a question? Guys, raise your hand so I know. I do have some names written down, but I didn't get to see them all. Veronica, you're unmuted. If you want to talk, you have to unmute.
I accidentally hit the button. I'm sorry.
Oh, no, that's fine. Iona, you have a question? Go ahead.
Yeah, hi. I wrote a couple down. Hi, Julian. Please forgive me if you just went over this earlier because I came in late. But when I came in, you said to somebody, when you say if you do have any problem, then you do an acceptance and rescission. I'm assuming that you're talking about if you have a problem on any contract. Is that correct? Or I do have a couple more questions on that. I just wanted to get that straight.
So the rescission is for if you entered into any contract by mistake. If there's any contract that's coming back to haunt you, a form you filed with the IRS, something you signed in a courthouse, any issue that you got yourself into, if you signed a traffic citation even, then you would use a rescission on that. There's a very specific way that it needs to be done.
Oh, there's a specific way? Because I was going to say, so you don't really even, like, if you have any debt collector coming at you, right? And I wrote this all down, but now I can't read my writing. So if you have a debt collector coming at you and you didn't have a contract with them and the original creditor hasn't recognized any of your other attempts for communication, why would you think that they would notice the recension? You know, I mean, I guess maybe they do. Have you had any experience with credit card companies and or of the such?
I mean, tons of experience with credit card companies. That's one of the easiest things to handle in equity, just because what we're doing, they're able to take our acceptance to the Fed window and generate digital dollars that get put into their account. So it's not like we're fighting them. Mm-hmm. We are honoring the contract. We're just not paying with the green stuff in our wallet. We're paying with our signature instead. So there's a very specific way that this acceptance needs to be done, because this is banking. It's very serious, and if you can't do it haphazardly.
Yeah. So Julian, I looked up acceptance all morning for this acceptance, and I could not find the specific wording. I found some specific wording for different things that go to the National Bank Association. So could you be specific?
Yeah. Well, I mean, if you take the class, I get into extremely deep specifics on exactly how this is done and where it comes from and where it spells it out in their law books. I teach right out of their dictionaries and their thesauruses to show you exactly how this acceptance works, where it came from, and all that. So, I mean, I can't kind of describe the entire process right now, but suffice it to say that I've discharged tens of thousands of dollars of debt with credit card companies. My mentors discharge millions of dollars of debt with credit card companies, and these matters very rarely go to court even. I mean, banks might push back a little bit, but after a few months, the matter's pretty much over, and you don't ever have to pay with the green stuff in your wallet again. You just pay with your signature from now on.
Oh, they don't notice a trend and decide they don't want to do business with you after you do that. And if, you know, they should just be fine because they get to take it to the window. But, you know, I thought maybe, anyways.
People are still able to maintain their credit scores. I mean, my wife's credit score actually went up when we brought equity to her credit cards. But some people's go down, so there's also a separate credit repair process that I teach. It's not equity, but it helps people with that situation. Close the account. So equity seeks to do justice and not by halves. It's a maxim of equity, and basically it's saying that equity will close the account. You can't keep using that same credit card. So it fully settles that matter, discharges the debt, And you can apply for other credit cards in the future if you decide that that's something that you want to do.
How do you feel about the rescission of the original contract of being an federal employee? Like, when do you decide that you want to deal with that?
Being a federal employee?
Yeah, with the social security number that you were given, that might have been an error. How would you go about that?
I mean, you can always rescission that on behalf of your mother who signed it, who signed that SS4 to get you the social security number in the first place. You also want to do that SS4, but that's a whole nother matter. The Trading with the Enemy Act says that if you return the property of the United States, then you can't be charged. So if you're ready to return their property to them, their birth certificate and their social security number and all that, and you have a darn good alternative worked out to where you know how to stand on it in case you're ever challenged, then go for it, and I can teach you how to rescission it at least.
Okay, thanks. I appreciate it. I'll let someone else ask questions.
Thank you.
Lucky, you had a question?
Yes. Can you hear me?
Yes, go ahead.
I would like to know when you mentioned the land title and the foreclosure, if you use the land, and I might have the terminology wrong, so I apologize. I believe you said, or I deleted it already, that the land title would stop a foreclosure. Would that work in a non-judicial situation, or is it only in a judicial situation?
Sure. So what I said was that the land patent buys time in a foreclosure. It does not usually stop a foreclosure from my experience, but it can buy the person time in order to learn equity, and then they can use equity to stop the foreclosure. Ron Gibson's actually speaking with my mentor on and off in order to try and learn how to apply equity to the land patent process. Right now, Ron, he understands a great deal about common law and commercial law, but he hadn't really even heard of equity before my mentor. So they're in talks together to try to beef up that land patent. But in the meantime, we highly recommend that if you need to buy time in a foreclosure, but not to stop a foreclosure.
Thank you.
Mark Tislin, you had your hand raised before. Did you have another question?
I did. Just one more quick one for Julian. And this might be a little reminder of my attempt to reach out to you a while back when you started your classes. And maybe this is a great gauge of whether or not I'd be a good student of yours. What about you lean my strawman account and I will do an acceptance and get you paid back that way? Will that work?
I don't have access to the Fed Reserve, so the Federal Reserve window, so I can't. It's just banks, insurance companies, credit card companies, hospitals, courts. But yeah, I'm just a private individual, so unless you got a Rothschild cousin in your back pocket that we could talk to.
I thought you were a private banker though as well.
Equity teaches us how to use banking laws to do our acceptance, but you can't, like, if your neighbor loans you $10, you can't just do an acceptance on it and tell the guy to, see you next Tuesday, buddy. I paid you back. He put his blood, sweat, and tears into that money to loan you, and he doesn't have access to the Federal Reserve, so you can't really do anything with your acceptance. That would not be honorable.
Yeah, I get that. Even though really the money's just promissory notes, so it's really a promise to pay anyways.
Yeah, and it's just evidence of a debt. You can't pay debt with the debt, but at the end of the day, the workman's worthy of his hire, and he needs something to exchange for food.
Yeah, I know that reality. All right, I just thought I'd check that one, see if there's something we could do there. Thank you.
Thank you. Miss Yelp, you had a question?
Thank you. I was curious to Julian's class and whether it can help with one who has done a land patent and home was taken and all assets and the case is now dismissed, so there's no millstone around one's neck, but wanting to know how to restore one's life moving forward. I yield.
Yeah, first of all, thank you for waiting so long to ask. And there is a redemption process in equity. So no matter how much time has passed, there is a process by which we can redeem the things that were taken from us, because equity abhors a forfeiture is a maxim of equity. So redemption is a equitable process. It takes a lot of time. It takes a lot of effort. It takes not just weekly, but near daily notices. It could take a year or two in order for the redemption process to fully work itself out. And you would need to ask yourself, is there another family living on the home? Do they have children? I mean, how would I make them whole if they were removed from this house in order to redeem it to me? So my mentor has shown me how to do that, and he's redeemed properties for people. It's an extremely lengthy process and expensive and time consuming, but that is possible, yes.
Thank you.
Moving forward, I mean, equity can give you just absolutely the best remedy so that any issue that comes up in your life for the rest of your life and for generations to come, you'll know exactly how to handle it, how to stay in honor, and how to be left the heck alone and remain in your home.
Bless, did you have another question? You had your hand raised earlier.
My question was, someone had mentioned before about her being on the mortgage by herself, and that kind of happened to us with this new refinance that we did. So I was just wondering, there might be something more involved than I'm realizing with my mortgage, even though everything's up to date, but I still don't trust these people, so just your comments on that.
I mean, yeah, if you ever need to defend yourself or your home, then equity will give you absolutely the best chance of doing that successfully. Now, as far as looking into the issues with mortgages, I mean, you can do a chain of title claim. You can look at Ron Gibson's material again. The fact that the promissory note and the deed of trust are split after the signing, but they lawfully are not supposed to have any value when they're separated from each other. However, the promissory note is immediately fractionalized, derivatized, and traded on stock markets all around the world. So, yeah, I mean, these are some issues, and certainly we use them to craft questions that we use to help compel performance. But there are many, many families that are going to be able to stay in their homes for the rest of their lives debt-free because of equity.
Do you think a forensic audit is something to consider?
It could turn up some useful information to form into equitable questions, but again, I mean, it's not going to solve the matter. It's as far as I know, I mean, equity is the only thing that gives a 100% guarantee of being able to do that, so long as you properly apply it and fully internalize it. Now, a forensic audit could give you some fuel for some good equitable questions, but just in and of itself, no.
Okay, thank you so much.
Absolutely, and I've time for one or two more questions, Michelle.
Okay, God's child had their hand raised earlier. I unmuted you. Do you have a question?
Yes, I do. Yes, I do. Sorry. And speaking about this equity, and you're kind of dating it back to biblical and all, and, just getting acceptance. I mean, what's really the take on this? I mean, as far as getting everything free from the matrix, because I've learned one thing out of the Bible is about the Tower of Babel, and how God scattered everybody from one end of the earth to the other, so nobody could understand anybody's language anymore. But how does this really tie biblically on getting us where we need to be as far as out and away from them?
Come out of her, my people, Revelation 18. Come out and be ye separate, touch no unclean thing. There's many verses in the Bible that talk about just coming out of Babylon, being in the world but not of the world, not looking like the world. I mean, I don't know anything else that teaches you how to properly operate in commerce while not getting yourself entangled in all the contracts that most people have to get into in order to do that, like equity does. Equity teaches you how to stay out of those contracts, but still operate in commerce if you need to. Equity teaches you to agree with your adversary so that, like Matthew 5, I mean, agree with thine adversary quickly, lest he turn you over to the judge, who turns you over to the officer, who throws you into prison, where you won't come out until you've paid the uttermost farthing. Equity tells you how to agree with your adversary quickly. Equity takes the wind out of their sails by not arguing, not creating controversy. They don't know what to do. I mean, attorneys are taught their whole lives to do nothing but argue. And so when we come in and say, I do not argue the facts, law, jurisdiction, or venue, it takes the wind out of their sails. And, Jesus, when he was questioned by the Pharisees, he just asked questions. And that's what I teach people to do. So, and also, I teach you how to not be tithing your first fruits to Babylon. Like most people just fill out these IRS forms without even thinking about it. I teach you not only how to not have to do that, but how to compel your employer in a totally ethical way to not withhold taxes from your paycheck, and in a way that they're going to accept, in a way that's not going to sound weird to them, in a way that just easily compels them to stop stealing the fruits of your labor. And then if the IRS ever comes knocking, I give you a remedy for that too. It's entirely lawful, 100% lawful. It's according to Babylon's own laws, in a way that I believe God has preserved for his people.
Well, I really appreciate that, man. What I've been doing, I've been looking into a lot of this, reading a lot of legal stuff. I've really seen how they've actually snared us and caught us. I couldn't really find the way out without listening to you guys and what y'all are doing. How can I get a hold of you?
You can message me on Telegram. If you click on my name here, you should be able to send me a message from that, or it's you just type it in on the search bar there. It's @ V as in Victor, I, T as in Tom, I, A, T as in Tom, E, and then the number 0, @vitiate0. And that way you can private message me.
Thank you, sir.
My pleasure.
Brian, you had your hand raised. I unmuted you. If you have a question, go ahead.
I was just, it's something somebody said earlier about, taking the process and doing that. And Julian was telling him that he's not a private banker per se. So that I'm just wondering, what about a syndicate? What about a group of us coming together and doing something like that? What are there? Is there venues and avenues that I'm sure that there's got to, because the way they've gone about doing that, there's got to be a way, don't you think? Or is there a way? Do you think that that could be done?
Private message me, but if you need help coming up with the amount for the class, then I do allow you to split it with somebody if you need to. So if you want to get one other person and split the cost with them, then that would be okay with me.
Okay, great. Thank you. Thanks, Michelle. I hope you're good.
You're welcome, Brian. Julian, real quick, with the class, do you offer any kind of payments or anything?
So you can pay in 1, 2, or 3 payments. The cost goes up a little bit for 2 or 3 payments, but not much.
Okay.
And yeah, those are the options.
Okay. So True North also studies under Yoda and such, and he does have a question for you. So I did unmute him. Go ahead, True North.
Good evening. I was just curious as to who you never did mention who your mentor is or who you studied under. I was just curious. Yeah.
He's a very private individual, and he's just going to have to remain private.
Okay. M, you had your hand raised.
Hi, peace to all. Thank you, Julian. I had actually messaged you some months ago because you had a class before, but I joined this call here tonight late, so I missed some things you said earlier. But also just wondering, like the price range from I guess from one payment to 3 total. But what's what's the price for the class and when does it begin and how long is it and whatnot. Thank you.
Yeah, I remember you. You sent me the document about the history of equity, and you had a question, I think, about a rental property that you had gotten involved in. But yeah, just private message me, and I'll give you those details.
Cool, thank you.
And Iona, you have another question?
Yeah, it's just a quick one. I know he's getting tired probably. So I've had other people try to explain to me the difference between exclusive equity and the commercial equity that's out there. And I'm just hoping, I know you went over and said, well, there's the pre-1933. That's why it's only, we get exclusive equity, but when people study those books from before, they're not getting that. If you went over this already, please forgive the question a repeat, but could you possibly give me any other way you could know what exclusive equity is?
So it's, I think, there's a lot of different terms that people use to refer to each pre-1933 and post-1933 equity, but I mean, the one that's kind of different from what I'm teaching is what Rourke teaches. So if you're familiar at all with Rourke, I mean, you can learn a lot from the guy, but he doesn't have a real remedy because obviously pre-1933 equity doesn't work after 1933. So the equity that I teach has only been in practice for about 10 years now. It took a long time for people to figure it out after 1933, but it just takes into account the fact that all the laws were changed to say payment or acceptance, payment or performance, and that's what we do. So I can take one more question.
Okay, Cheryl had her hand raised for a while earlier. Go ahead, Cheryl.
Hi, Julian. First of all, thanks for coming. It's been real nice. I didn't get to hear the whole thing. I was over in another group. We all got to say hello to Holly, by the way. Anyways, our prayers are with her, another lady that has a group. But yeah, my question is really super simple and short. But thank you for being here. I just wanted to ask about, you mentioned about if there was like a family in a house, like my house was like foreclosed on and, going back on that, but isn't there a way that we could just get like the value, equal value or something like that, where we wouldn't have to put someone out of the house, get another house per se, the value of what my house was?
In redemption, I've heard of people being redeemed, and a secondhand knowledge of this because it's a very lengthy process. My mentor has done this for people before and taught me everything he knows. So I've just heard of people getting the actual items that were seized from them back. You could probably get the value of it. It would depend on what the court wanted to do, but it would be one or the other, certainly.
Mm-hmm. Okay, I just remembered, I think Rob Ryder did something on this. Huh. Okay, Julian, yeah, I appreciate you very much. Thank you. Thank you, Michelle.
You're welcome.
You're
Let me
welcome.
just let me just comment on that real quick. It has nothing to do with equity, but if anybody did have a foreclosure and there was a profit made, that person that owned that property that got foreclosed on by law is entitled to that profit, and you don't have any time limit to collect on it. Just so you're aware. I do know that.
Okay, thank you.
You're welcome. All right. Julian, there's 2 hands raised. I don't know if they have quick questions. If you want to take them real fast and end after that, that's up to you. Just tell
Sure.
me.
Real quick.
Okay. Go ahead, Akitas.
Oh, perfect. Peace and love, man. I just wanted to know how long you actually been in the movement of this equity.
So it's been about 2 years that I've been studying it, and
Okay.
just throwing myself into it that whole time. And my mentor about 7 years.
Phenomenal. Other question: what is the requirements that you take when you're taking on new people?
I just ask that you sign a privacy agreement. I mean, you don't need to do any kind of status changes or have taken any other courses. I teach you everything that you need to know.
And and I don't know if you mentioned it prior, but what is your whole end goal in this situation or system itself?
I just want to help people come out of Babylon. I want to help God's children stop getting ensnared in these contracts and losing their families and their livelihoods to basically demonic trickery. And I'm just trying to be used to the Lord and earn food for my family while I do it.
I see. And now, what was your reasoning to come out into the public with this equity instead of keeping it private?
Well, it's still private. I mean, it's a very private remedy, and it needs to remain so. Because if this winds up on YouTube or something, it's just going to get diluted. And it'd be like putting a loaded gun in the hand of a child who's never shot before. I mean, it's an incredibly powerful remedy. It puts the silver bullets in your gun, but you need to know how to shoot. And so yeah, I'm not making this public, and I would rebuke strongly anybody who wanted to.
Okay. Yeah, I just realized because the actual call was being recorded, and typically when we're dealing with reason and authority, we exclude all recording and we keep everything private and stay away from the public. So that was it. Thank you.
I don't mind the recording so long as it's not being passed around all over social media. I mean, it's going to stay private. It'll get passed around from word of mouth, but people need to learn this remedy. I mean, it's the greatest way, I think, of putting a check on just the brokenness of this system and protecting families for generations. So you gotta do what you gotta do. There's one other
Lanny, you
person.
had a question? And that's going to be the last one. I guess we'll wrap up. Lanny, did you have a question?
Yes. Sorry about that. I was muted. Thank you, Julian, for your time tonight. Very informative. I just had one comment and just one quick question. As to the clerks hiding information and hiding the oaths, look back to the authorities that delegated that power. In my state, the chief financial officer in his policies is telling them exactly how to hide the money and how to handle open records requests. If you dig enough, it would be addressing that with their higher authority, not necessarily the person that's standing in front of you. And they do use fictitious names. If you're curious, you just go to the official records daily on your courthouse, and you'll be surprised how many court staff members are doing instruments. They're required to do so in order to ship your bonds up to the general pooling fund. So for those that can't get an oath or can't get a bond or anything, there's a little bit of a little bit of a trail that will give you the person's full name. And Julian, I was successful in having 2 cases dismissed in I guess it was an equity. I didn't argue. I simply advised them that I had canceled any contract since the time of the controversy to the time that I appeared in court. My question is, the last, I guess, case management status update that was scheduled after being jailed twice on the case, and that's an injury that I'll follow up some other way. I asked the judge's assistant by email. I first called and I got their email, and I requested an in-chambers equity meeting of sorts, and it was denied because it's an ex parte communication. What is the best method to approach if you don't start an equity? Although I felt like I didn't argue anything. They didn't know what to do when I told them I don't have a title, I don't have a registration, I don't have a license. I've canceled those contracts. There was no further activity, that should have been done on the case. What is your best suggestion in that?
I recommend that you take the class and learn how to do it properly. What you're talking about with private chambers, that's pre-1933 equity. So I would recommend taking the class so you can learn post-1933 equity, and you'll start seeing a lot better treatment when you go to court.
Okay. All right. And I wasn't aware of that. I learned something new tonight. Thank you.
Absolutely. And thank you so much, Michelle, for giving me this opportunity to talk to everybody. And Rick, if you're still here, it was good to talk to you. Good to meet you. And thank you very much, everybody. Private
Thank you.
message me
I'm
on.
sorry. Go ahead.
I was just going to say, private message me on Telegram for any more details. If any of you have any questions, and I'd be happy to answer them for you.
Yeah, and I'm going to put the video, the recording of this together, and with the announcement like we did last time, for people to get in touch with you to sign up for the class. Is that what you want me to do? Is that all right?
Yeah, sounds good.
Okay, great. Thank you for coming on. Thank your wife for coming on. And I'm sure I'm already getting messages now that people are going to contact you. So they want to sign up for your class. That's awesome. Okay, guys, I'm going to end this recording, and then I'm going to start a new one, and then we'll go to open discussion. And Julian, once again, thank you so much for coming on. Truly appreciate you and what you're doing. And thank you so much. If you want to stay, you're more than welcome.
Thank you so much. And again, you can contact me on Telegram at vitiate0. That's VITIATE number 0 on Telegram. And thank you so much, Michelle. And God bless you all. And have a good night.
Thank you too.